speak today. It's a real pleasure to be here to speak to so many experts in the field. The topic of my presentation is, of course, experts and the federal court. What I'm going to speak on, going back to what Leah was saying, is applicable equally if you are working in a rep body or whether you're working as a consultant anthropologist. It's applicable whether you're early career, mid-career or late career. So hopefully there'll be something in the presentation for everyone. Before I move on to talk about experts conferences and hot tubbing, I did want to just, of course, remind everyone about the duties of an expert. It does run through all of the work that's been done by experts, whether that be preparing an expert report as part of negotiations for a consent determination, reviewing an expert's report, participating in an experts conference, or giving evidence in a court proceeding. I do emphasise this. I know you've all heard it before, and it's probably banging the drum, but I think you have seen recently some of the implications, both for the experts themselves, but also for the group that you might be providing evidence for or writing for. A recent example I'm sure that you're all familiar with is the Mankara decision that was decided by Justice Charlesworth last year, that really does emphasise the importance of an expert's duties. These are set out quite clearly in the court's practice note on the duties of an expert. It's available on the Federal Court website. I'm happy to make the link available for any of you who may not have had the opportunity to read it thoroughly yet. But the most important thing is that experts are not advocates for the party that has engaged them. Their primary duty, particularly when you're in a court proceeding, of course, is to the court. The purpose of the expert evidence is for the court to receive the benefit of your objective and impartial assessment of an issue, being someone, of course, with specialised knowledge or specialised training. This objective and impartial assessment needs to be clearly set out, and the assumptions on which your opinions are based also need to be readily apparent in the report or the oral evidence that you give. So in other words, it's your reasoning that really matters as much as the conclusions that you might reach. I appreciate that, particularly for those of you that may be employed by rep bodies, it can be very challenging to balance your duties as an employee and also an important piece of the jigsaw puzzle when rep bodies are putting claims together. It can also be very challenging when you've spent extensive time in the communities that you're writing about and may have developed very close friendships or affiliations in those communities. There is a really great video on the CNTA website. It's a discussion between David Trigger and Rob Blouse about some of these issues and how they recommend you go about managing them or answering questions that might be raised that challenge your expertise because of those factors. That's just one of a number of really great podcasts that are there, so I can't recommend that enough. The other thing that's important about being an expert is to stay in your lane. And what I mean by that is, as tempting as it is to maybe offer an opinion about a linguistic issue or historical issue, it's better for everyone that you don't. And that's because one of the criticisms that we see if criticisms are made of experts is that they go outside their lane and start to offer opinions about areas that's not their specialised knowledge or their specialised expertise. So just moving on then, I won't talk much today about preparation of an expert report. That's something that is often away from the eye of the court about all of the work that goes into those wonderful reports that are made available as part of the negotiation or ultimately the litigation process. But what I wanted to talk about is experts conferences and then hot tubbing. Experts conferences, we have anthropologists who are both consultants and in-house, and by in-house we mean those that are employed by rep bodies participating in experts conferences. And I can't emphasise how important they are for resolving matters that may have not been otherwise resolved before. Very often what you'll find through an experts conference is that issues that have been not agreed or perhaps not fully discussed between the experts, because you might have had a battle of correspondence or a battle of reports that don't necessarily go always to the heart of the issue. When the experts have the opportunity to actually sit down and talk to one another, very often the issues in dispute are resolved entirely or at least narrowed significantly. So for those of you who may not have been in an experts conference before, I thought I'd just go through a little bit about what they are, the process for them, and just from my personal experience, of course, not a view of the federal court, about what works well and what doesn't work well in an experts conference. So experts conferences can occur at any point in the proceeding before the court. Very often they will occur towards the end and often when a matter is in trial. They're an opportunity for the experts to meet without any lawyers being present to talk about what might still be in dispute. The intention of the experts conference, of course, is to ideally resolve any issues that might still be in dispute. But if that's not possible, then it's to look at why the experts may not agree with one another. There's nothing wrong in an experts conference if the outcome is that you still disagree. The whole point of the experts conference is to listen to your colleagues, listen to their views, why they have those views. And if it changes your mind, that's fine. In fact, we've seen that very often. Even the most senior anthropologists will pause and think about their opinions, and sometimes they change and sometimes they don't. Before an experts conference, the court will ask the lawyers, and it's intended to be in collaboration with the experts. I realise that doesn't always happen, is to put together a series of propositions. The purpose of the propositions is that they frame the discussion in the experts conference, and they're usually expressed as a yes-no answer in order to focus the discussion and then a reason for why you might have that dispute or disagreement. So where, for example, a point in dispute was whether native title rights included the right to take and use resources for any purpose, one proposition was, prior to sovereignty, long-distance exchange routes crisscrossed the continent. So then it was an opportunity for each expert to offer their opinion on that, and the registrar would assist who was convening the conference to draft any notes that might be taken based on that discussion. Another example would be where the claim area, it appeared the claim area was a meeting point of multiple societies. At effective sovereignty, the claim area was shared or transitional zone for the societies identified in a particular proposition in which the relevant rights and interests were shared or coexisted. So, as I said, the propositions are designed to focus the discussion. My tips would be mindful of how long the propositions can take. So don't come up with too many. And please bear in mind that what we're talking about is native title. So while other propositions might be interesting, what we're looking at is native title. For example, I had one expert work with their lawyers to come up with 72 propositions to talk in a single day. Needless to say, we ended up with 4 propositions. So it's just trying to keep that balance between what you need to know and what you might want to know. It's ultimately the registrar who's conducting the conference that settles the propositions. Ideally, both parties will agree on the propositions, but that's not always the case. So if they can't, then the registrar will settle the propositions and send them back to the legal representatives. They would then be shared with the anthropologists prior to the conference so that you can have a think about them, think about what you might want to say, but not prepare your written answers in advance. It's important that the anthropologists attending ensure that they're familiar with all the material that you've based your opinions on and with the reports of the other experts. And the propositions, as I said, provide an indication of the framework for discussion. So when you come to the conference, the registrar will confirm with the anthropologists that they have seen the propositions. Unfortunately, sometimes that's not always the case, or that they haven't had an opportunity to be involved in the discussion. If the anthropologists don't agree with the propositions, then that's one of the first discussions that we have. Sometimes they are changed, and then sometimes during the course of the discussion, we add them. So, for example, we did one conference and we got halfway through and realised there were no propositions about how rights and interests in land are transferred. So from one generation to the other. So that was a fairly big oversight, and that proposition was then added in. So the role of the registrar, it's really simply to facilitate the discussion. That might involve bringing the experts back onto topic, because we often see anthropologists getting really into the discussion that they're having, and then they head off down a pathway that may not necessarily be relevant to the native title question. So it's also time management, reminding the experts who will ultimately use the report. So don't forget who's going to read the reports that you write. Sometimes it might be another anthropologist, but most often it's the lawyers, and ultimately it will be the judge. So this can also sometimes cause a little bit of angst with anthropologists, because the terminology in the Native Title Act doesn't always reflect the terms of art that you might use in anthropology. So one of the challenges is writing for someone who may not know a lot about anthropology. The registrar might also pose questions themselves, and that might be also based on the registrar's knowledge of the matter, what some of the points in dispute are, and the registrar, of course, will help draft the conference. If the conference goes over multiple days, then the anthropologists are asked not to speak to the lawyers, because this is a conference about anthropologists. The lawyers don't have any input. They can have a look at the report once it's done, but we also generally conduct the conference on the basis that whatever your discussions are, that's for the conference only. So what goes on in Rome stays in Rome, and what comes out is the report at the end. So how are the reports used, or what do they look like when you're finished? So the structure is it's referenced to the propositions. Sometimes there might be an executive summary at the start if there are issues that you particularly want the lawyers to take account of. As I said, it's really important to remember that the ultimate consumer of the report are mostly lawyers. But you would be amazed at how often the views of the anthropologists can shift the views of a lawyer. So what might have previously been an immovable force all of a sudden becomes not quite so daunting. And it also gives lawyers something they can hang their hat on for why they're going to form the view that they form. So please don't underestimate that. Just from a personal perspective about things that seem to have assisted or been detrimental for experts conferences. Number one, please don't pre-prepare your report. Or your answers. We have had experts turn up with a USB and go, here you go, here are my answers to the propositions. That just completely defeats the purpose of the experts conference, which is to openly discuss and listen to your colleagues. Secondly is be polite and respectful of all the views, not just the views of the well-known anthropologists. So everyone has a role to play, everyone has a view, and everyone's view needs to be taken account of. Also, don't be overly aggressive or defensive, particularly the defensive and the aggressive. It just makes you look like an advocate or that you're not impartial. But do be prepared for robust discussion. It is an exchange, an open and frank exchange of your views, and you are expected to defend them, but that doesn't mean that that's it. It's an immovable defence. And also stay on topic. It's amazing how anthropologists get fascinated by each other, and before we know it, you're off and running. And which leads me to my next, be prepared for the registrar and cut you off. The other thing is when you get sent a draft of the experts report that might have been drafted by the registrar, please don't add in anything that you didn't discuss at the conference. If there's something that you think needs to be talked about or you haven't had an opportunity to provide your opinion on, then talk to the legal team about maybe providing a supplementary report or something further along those lines. And if you're unsure during the conference or you feel a bit overwhelmed, for example, it's your first conference, then tell the registrar. Every registrar has started off, hoping they're not going to have a magnitude 9 cock up during their registrar at their conference, but everyone has to do something for the first time at some point in their career. So that's experts conferences. If I can just talk about hot tubbing, which is not my favourite term, probably better might be concurrent evidence. So concurrent evidence is where we've moved a little bit further down the line in the legal proceedings and you're actually giving evidence in court. In many ways, the process of concurrent evidence is quite similar to an experts conference. So the process, experts are generally asked to give evidence after what we call lay evidence, and lay evidence is generally the Indigenous evidence. And it's essentially a discussion that's chaired by a judge. So the process for hot tubbing is that all the experts are sworn in at the same time during the trial process and their reports are tendered. The judge will explain the procedure. So you might have a table in the courtroom and all of the experts will all be sitting at the table so that they can all give evidence at the same time. There's usually a series of topics for discussion during the hot tub. And they're effectively the outstanding issues, and they've been generally agreed between the lawyers and the court. Each expert is asked by the judge to give their view on the particular issue in turn, so you go one after the other. The experts can also comment on some of the other experts' views. They might want to ask questions of their colleagues in relation to the evidence or the report. And the only real rule is that if you have the microphone, it's your turn to talk. The court then asks counsel or barristers if they've got any questions, and they might ask some questions of their own expert witness, or they might ask questions for some of the other experts. And then the judge might ask some questions. The benefits of it really are that you get all of the expert evidence all at once, rather than one at a time, one after the other, where you lose momentum. Because the experts are talking to each other, you're also more likely to get people talking about things that they understand, as opposed to, with the exception, of course, of some of the barristers who are here today, who don't necessarily understand what's being said or have that grasp of the subject matter in the same way that you all do. If you do want to have a look at what an expert conclave or hot tub might look like, the New South Wales Judicial Commission has a really good YouTube video where they talk about the process, and they also do a mock of what it looks like when people give evidence in the hot tub. It's not anthropologists that are the experts, but it's exactly the same process. So if you're interested or you ever have to do it and you want to have a look at what you do during hot tubbing, then I'd recommend this DVD, because unlike many other processes in the court, there's no actual practice note or strict rules about how it's done. So other than, talking to the lawyers who might be able to help you about what to expect, sometimes it helps to actually see it in practice. So just moving on to the final point, because the theme of this year's conference is solutions to and challenges in the native title anthropology workforce, just wanted to talk through a few things that the court is doing in this space, mostly just for information, but also if any of you would like to be involved, we would very much welcome it. The first is we do a series of CPD, which is professional development for young lawyers. We started last year and it was all particularly legally focused, but this year we're lucky enough to have Louise Allwood come and talk as part of that to the young lawyers about some of the anthropological issues or challenges and working together with lawyers. So the topics that Louise is going to look at is an introduction to basic concepts, a discussion on the requirement of anthropologists to remain objective as opposed to a lawyer's position as advocate and what this means on the ground, an explanation on how anthropologists elicit information differently to lawyers, the role of anthropologists in decision-making meetings, including determining whether traditional decision-making has been followed. So if any of you are interested in attending any of these, I'd be happy to leave the link with Julie, or if even better, if any of you are interested in presenting on any topics, I very much welcome that. And finally, the other thing that we would welcome is noting some of the issues that David was talking about sort of the challenges with continuing training and emerging anthropologists, and perhaps also the shortage that we have of people who have experience in the field, is looking at different ways of taking expert evidence and looking at different ways of using anthropologists in the processes. So as you may be aware, generally the process is a report gets prepared, it's given to the state or the territory, they review it, they come back with some comments, and it can be a lengthy process and it can consume a number of resources in doing that. So questions that the court is asking is whether this current model is the most efficient. And looking at, for example, is it a good idea to have an experts conference a lot earlier in the process? So, for example, would you have an experts conference before you actually put pen to paper and start drafting the reports to try and work out what the real issues in dispute are before you start writing? Another one might be, could you have a single expert that is briefed with a joint terms of reference so that a single expert's report is presented? The other one that we might be looking at is whether you might in fact just rely on the report that comes out of an experts conference. So there's all different things that we'd be looking at, and as anthropologists we would be very interested in hearing your views about some of the challenges of these perhaps new approaches or perhaps more streamlined approaches. So other than to say thank you for all the work that you do, it's the court, I know, well, I love personally doing experts conferences in particular. I love reading the reports. It's always a pleasure, sometimes a challenge because, you do get very involved and very carried away sometimes, but it's always lovely. So